I'm telling you, I'm tired of those executive orders that undermine civil rights and that's trying to get my head to spin and get me mental whiplash. I'm not going for it. I've decided to control those things that I can control and leave the rest where it is. If you face discrimination and you filed a complaint or charge, I'm sure you want that case settled favorably or resolved favorably. And there's two ways, in my view, that you can get that done. You can go to trial and get a discrimination finding against that perpetrating official, or you can settle the case. Sometimes it is best to settle, but that's not what I'm here to talk to you about today. I'm not trying to convince you to settle. I want to talk to you about what if you're able to successfully to get to a settlement table and that was your choice. You need to know about the four corners rule, because after all that blood, sweat, and tears, you do not want to find yourself vulnerable to a breach because your employer didn't do what they said they were going to do. Now, let's talk about what I'm talking about with the four corners doctrine and the settlement agreement, which is a contract. Settlement agreement is a contract. Now, suppose you signed an agreement to end your discrimination case, and then later your employer breaches it. Again, didn't hold up to their end of the bargain. You want that deciding body, whoever it is, to make your employer do the right thing. That is, live up to the bargained agreement. Now, under the four-corner doctrine, the court will rely on that written instrument, that settlement agreement, and they can't look at anything else to figure out what you or your employer meant. Therefore, whatever you do, be clear, be very clear about what you want. Because when terms aren't clear, the four corners rule. So if you're planning on selling and perhaps you want to negotiate telework or training or something else, be clear about the who, what, where, and how long, because neither the court or EOC will enforce that agreement or what you want if it's ambiguous. Now, I'm going to give you an example of a settlement case gone wrong. I even had an attorney, okay? I filed against my employer. It was a federal case, but it holds true. This four doctrine goes whether it's private or federal. And I settled. I signed the agreement. I wanted to be reassigned from that discriminating official office, and they reassigned me. But I look up a few years later, and I'm back in that office. Well, I went to EEOC because I'm a federal and wanted them to rule in my favor and say, hey, my employer breached the settlement agreement. EEOC disagreed with me, as a court would, because they go by the four-corner rule. Now, I thought reassignment meant permanent and detail meant temporary, but they said, EEOC, at least in this case, said it was ambiguous. Now, so what am I saying to you? Be clear. If you want telework, say telework for 12 months. If you want it indefinitely, you better say indefinitely. You need to be clear, and here's some examples. And this administration is going to have your head spinning, so control those things that you can control.